Welcome to our panel on cities and constitutional change. My name is Richard Albert. I'm professor of world constitutions at the University of Texas at Austin. I'm also one of the conveners for this conference on constitutional space for cities, hosted by Massey College. Excited about this day. It's the third and final day of the Massey Cities Summit. There are so many people to thank for bringing you this conference. First, the conveners, Nathalie Desrosiers, Alexandra Flynn, Alan Kaspersky, our team, including Darren Chow, Selena Zhang, Jamie Bajan, and Diego Rada, and our supporters, the Canadian Urban Institute, the Maitre Foundation, Massey College, and the Social Sciences and Humanities Research Council of Canada. Thank you to all of you. I'm joining you today virtually from the campus of the University of Texas at Austin. This campus is built on the indigenous land of the Tonkawa, who lived here in central Texas. The Comanche and Apache moved through this area as well. And today, various indigenous peoples from all over the globe call Austin home. I ask you to join me, please, in honoring the many diverse indigenous people still connected to this place. And please also to join me in acknowledging the painful history of forced removal from this territory. I'm deeply grateful and appreciative of the opportunity that I have to work and to study and to learn on this land. It's fitting that this panel comes on the third day of this three-day conference because so far we've learned about so many exciting ideas about how to rebalance powers in confederation in order to recognize the role and centrality of cities in Canada. Speakers have addressed cities and the climate emergency, cities and indigenous relationships, cities and fiscal management, cities and governance, cities and the future of urban design, and so much more. Because cities are central to meeting this moment, the moment that raises so many challenges to us. Cities are central to the success of the country. They're central to the health, the safety, and welfare of everyone in Canada, from coast to coast to coast. Cities do a whole lot. But today, they just don't have the constitutional recognition as partners in the project of governing the country. So, what are the options for giving greater powers to cities in Canada? Powers they need in order to do what we need them to do. Is constitutional change possible to modify the powers of cities? Well, that is the very question that we'll tackle on this panel on cities and constitutional change. On the panel are four outstanding scholars, innovative thinkers, and really great speakers, as you'll see, who've each thought about this question and have ideas of their own about the path forward. Erin Crandall from Acadia University. Hoi Kong from the University of British Columbia, Emmett Macfarlane from the University of Waterloo, and Emmanuelle Richez from the University of Windsor. I invite you to learn much more about each of these panelists on the conference website, where you'll find their detailed bios, or just cast your eye to the chat box, which is to the right of your screen right now, because we've pasted their bios for you there. Before we begin, let me just offer a word of congratulations to two of our panelists who have just published new books. Hoi Kong has published a book on deliberative peace referendums, and Emmett Macfarlane has published a new book on constitutional pariah, reference regarding Senate reform and the future of Parliament. Congratulations to each of you for your contributions to our learning about constitutions and constitutional change. Here's our plan for this panel today. We'll begin with a few questions for the panelists to discuss among themselves. And the questions are going to be drawn from ideas that emerge from their written contributions to this program. You'll soon be able to see these contributions online and perhaps not too long from now in a book. And after a few discussion questions, we'll open the floor to each of you for questions and comments from you. And when the time comes, just put your question in the chat box and also identify yourself, and I'll be happy to do my best to bring them to the panelists. In fact, you can begin right now if you want to pose your questions. So let's just dive right in with our first discussion question for our distinguished panel. And I want to begin, if I could, with Professor Richez, because Professor Richez, Emmanuelle, if I may, you've classified the different strategies for empowering cities into two major categories: delegation and devolution. I want you, if you could, to please explain that distinction for all of us and maybe give us examples of each and discuss the strengths and weaknesses of delegation and devolution as approaches. And a reminder to each of you, please don't make the mistake that I did. Please unmute yourselves now, all of you, because we're beginning our conversation. So thank you, please.
Well, first off, I'd like to thank the organizers of this summit, especially our panel chair, Richard Albert, for inviting me to participate in this panel. So to get back to your question, Richard, delegation refers to when a government entrusts administrative units with sovereign powers. So by adopting municipal acts, Canadian provinces are in effect delegating their sovereign powers to municipalities. Therefore, municipalities play an important role as enablers of provincial power, but their constitutional status remains informal and subject to change. Now, devolution entails a permanent transfer of sovereign power from one level of government to the other. Although there has been calls in Canada to make municipalities a third order of government, giving them jurisdiction over certain areas, these calls have not yet been answered. The tendency in the provinces has been to adopt what is known as laundry list legislation. And this type of legislation only delegates specific powers to municipalities rather than granting them general jurisdiction over certain matters. So laundry list legislation allow provinces to exert great control over municipalities. They also allow a minimum of regulatory homogeneity across their respective territory, as well as to keep taxes low. Now, laundry list legislation limits the ability of municipalities to tackle important policy problems and also are subject to frequent legislative amendment, thereby making long-term planning difficult for municipalities. Furthermore, the offloading of responsibilities to municipalities is not always accompanied by appropriate delegation of taxation power to meet these responsibilities, thereby creating fiscal challenges for municipalities. Thank you.
I wonder if I could bring you, Professor Crandall, into the conversation now, because we've heard from Professor Richez this distinction between delegation and devolution. But Professor Crandall, devolution as a reform strategy, I think, could be more desirable from the perspective of cities because it entrenches their devolved powers. It gives them greater security. But there's a cost to doing that, isn't there? Which is that it requires a constitutional amendment to do that. And as you know, as you've written about, amending the Constitution of Canada is difficult, to put it mildly. You explain in your own written contribution for this program that amendment talk in Canada is often met with political trepidation, and also that in reality, amendment is in fact complex. So why the trepidation, and what explains the complexity of amendment in Canada?
Yes, so thank you, Professor Albert, for that question. So let's talk about this. Certainly, Canada's attempts to navigate its own complex amendment formula have produced this political trepidation. So at this point, the political trepidation and the complexity of the constitutional work itself are walking together hand in hand. But a good starting point is to note the parts of Canada's amending formula that we're probably most familiar with through constitutional politics, which are Section 38, the general amending formula, and Section 41, the unanimity procedure, require very high thresholds of consent and are therefore really difficult to meet under the best of circumstances. So For the general amending formula, which as its name should suggest is the general procedure for constitutional amendment for the Constitution of Canada, 7 of the 10 provinces whose population together constitute 50% of the Canadian population, in addition to the 2 houses of parliament, must give their approval. And for the unanimity formula, all 10 provinces and the 2 houses of parliament must give their approval. So a basic level of knowledge about Canadian politics will make it pretty obvious that substantial or unanimous consent is going to be very difficult to obtain. And that's been proven through efforts of constitutional politics. We've also made what are already difficult constitutional amending procedures more difficult by adding different statutory requirements on top of what is contained in Part 5 of the Constitution Act of 1982. So for example, at the provincial level, both Alberta and British Columbia require a provincial referendum before a resolution authorizing an amendment to the Constitution can even be voted on by the Legislative Assembly. And at the federal level, the 1996 regional veto law effectively gives a veto and constitutional reform to regions when using the general amendment procedure. And it's also important to consider that large-scale constitutional reform is a kind of high-risk, high-reward endeavor, and experiences like the failed Meech Lake and Charlottetown Accords of the late 1980s and the early 1990s mean that even today, Canadian politicians, especially those at the federal level, view the probability of negative political costs to be far more likely than the remote promise of constitutional rewards. And so hence the political trepidation. In your own research, Professor Albert, you've rightly pointed to the importance of understanding a country's culture of constitutional politics in order to effectively evaluate the difficulty of its amendment formula. So for Canada, this political trepidation born of past constitutional failures is an essential feature of Canada's culture of constitutional politics and has made an already difficult amendment formula more difficult. And so when we're talking about constitutional amendment, we cannot escape this culture of Canadian constitutional politics. And I'll also add that if we're looking to overcome this political trepidation, which I think is part of the goal of this summit, I think it's useful to remember that constitutional culture, like any kind of culture, is not static. Constitutional culture is a reflection of our law and society, and both are capable of change, even if that change is difficult. So in thinking about how to bring about this change, there is no escaping the fact that the general amendment procedure and the unanimity procedure are difficult thresholds to achieve, even under the best of political circumstances. So consequently, any constitutional initiative would be well advised to avoid both these sections if they can. And this is possible because the Constitution of Canada has amending formula aside from these sections of 38 and 41. And I think in our panel, we'll be discussing in particular section 43, the bilateral amending formula, and section 45, the provincial unilateral amending formula. And not surprisingly, recent proposals to constitutionalize cities have really focused in on these amendment procedures, in part because they're easier thresholds to achieve. So pursuing something that is relatively narrow in its focus, like greater autonomy for cities, that engages constitutional change under either sections 43 or 45 is much less likely to get tangled up in the history of past constitutional failures and may stand a greater likelihood of success. And in a kind of best case scenario, it might also have the added benefit of shifting the culture of Canadian constitutional politics, probably not a lot, but just enough that future endeavors do not face the same type of steep political barriers.
That's so very helpful, Professor Crandall. Erin, if I may, you've explained to us why there is this political trepidation about amendment talk. You've explained to us what makes it so difficult to amend the Constitution of Canada using the general default multilateral amendment procedure and also the unanimity procedure. But of course, you open the door for us to other ways of amending the Constitution of Canada. So in some ways, it might seem like it's frozen, but you show us that indeed it may not be. But of course, there are other ways of amending the Constitution of Canada, or changing it rather, without amending it. In other words, we can change the authoritative meaning of the Constitution of Canada without amending its text, without altering its text. And Professor Macfarlane, Emmett, if I may, you've observed this very point in your own work. Because one of the ways that the Constitution of Canada can change without an alteration to the text is by judicial interpretation. You acknowledge that courts could confer protected constitutional status for cities by giving teeth to unwritten constitutional principles like democracy or constitutionalism or the rule of law. So a question for you, if I could, Emmett, how would that work? And it's a good idea, in your view, for a court to do that.
Yeah, thank you, Richard. Yeah, I do have some concerns about relying too heavily on judicial interpretation to remedy what we validly perceive as defects in the Constitution. So a number of scholars have written quite recently with some antipathy towards the idea of provinces as creatures of the provinces. Municipalities as creatures of the provinces. And one of the challenges is that any plain reading of the Constitution makes the municipalities' subordinate nature quite clear. And so these scholars would be happy, I think, to see the court step in and lift municipalities up. But they kind of grudgingly acknowledge that there is a constitutional reality at play, not just in the text, but in terms of broad understanding and precedent. One of the areas of litigation where this recently came up is the Toronto City Council case, where the Ford government here in Ontario decided to slash the size of Toronto City Council in the middle of a municipal election campaign. The Superior Court justice in that case tried to address what the Charter of Rights claims were involved in Section 3 by basically importing Section 3 principles into a free expression analysis. And it got really messy because the plain language of Section 3 makes it clear that voting rights and the rights that flow from voting rights, like the right to effective participation, meaningful representation, apply only to federal and provincial elections and not to municipal elections. And so the Ontario Court of Appeal kind of rightly, in my view, kind of slapped down this attempt at kind of incorporating municipalities into that matrix of rights, which in many ways I would argue would amount to kind of not just judicial interpretation, but judicial amendment of the Constitution. Unwritten constitutional principles are another area where this argument has been invoked, including in the context of the Toronto City Council case. The court has articulated a number of unwritten constitutional principles and has recognized them in cases like the Quebec secession reference. And these include principles like federalism, democracy, the rule of law and constitutionalism, the rights of minorities. Normally, the court justifies its foray into recognizing unwritten principles as a way to help guide the interpretation of the text, to fill in gaps where there is ambiguous meaning, or to connect different provisions across the constitutional texts that we have as a way to help filter and understand the broader constitutional architecture. Unfortunately, I think in this case, where we see the invocation of unwritten principles, and so again, I'll go back to the Toronto City Council case, people pointed to, well, the province's law here, changing the size of Toronto City Council, that's a violation of the unwritten principle of democracy. And so the courts would be in their right to use this unwritten principle to nullify the law. I think that would go quite far, because again, it would fly in the face of the clear powers of the province to do this. And there may be legitimate concerns about certainly the timing of that law, and the effect it might have had on free expression of participants in that election. But to use an unwritten principle as the sole basis for striking down a law, again, I think trips into this territory where the courts are no longer merely interpreting ambiguous provisions or contested meaning. They are actually effectively rewriting the Constitution, and really engaging in what I call judicial amendment of the Constitution. And we have to be concerned here, because whatever legitimate concerns we have about municipalities and their subordination, whatever valid criticisms there were of the province of Ontario's meddling with the Toronto City Council, process matters, and there are legitimate and I think illegitimate ways of changing the Constitution.
Let me bring in the other panelists on this, Professor Richez, Emmanuelle, if I may, Professor Kong, Hoy, if I may, and Erin. Any comments on Emmett's point just now that there should be limits on what courts do, even if that means that cities cannot be given powers that you may all want the cities to have, but courts should stop short of exercising a power that perhaps they have that amounts to what Emmett calls a judicial amendment of the Constitution, even to do something that you might want to happen at the end of the day. Floor is open.
I think certainly Emmett's concerns are very valid. It is this question of when does constitutional supremacy cross the line into judicial supremacy, where it's the courts that get to decide what the Constitution says. But on the other hand, there is this kind of pragmatic I don't know how to say, urge to almost let the courts go ahead when you are faced with this kind of constitutional stasis, where there's a lack of political will to do things with the Constitution, to engage with the constitutional amendment procedure. We've almost defaulted in Canada to the courts, that any kind of movement we've had with our Constitution has come by the way of judicial review rather than through our elected officials. And this is not, I would say, a sign of a healthy democracy, that we have kind of allowed that to happen over time, that our expectation is that the courts will tell us what the Constitution says, and there's a lack of engagement amongst elected officials who also have a role in talking about what the Constitution is supposed to do and what it's supposed to look like.
Hoy, how do you see this?
Yes, so I think it's a great question, and it's a kind of perennial evergreen question. So, like, I think that there's a point to which the plausible limits of interpretation run out. Yeah. And so there's a point at which the judicial role is surpassed, because you really are no longer interpreting a constitution, you're doing something else. And so that has implications, I think, for, I guess, what Erin was calling constitutional supremacy, in the sense that once you do that, you've basically overridden not simply the text that let's say you're a court, you're the court that's doing this, not simply the provision that you're interpreting beyond the scope of what it bears, but you're also challenging, in effect, the amending procedures. Because you're circumventing the amending procedures. So that challenges what Erin is calling, and I think rightly, the culture of sort of constitutionalism, constitutional supremacy. The second reason why it might be an issue is that it also potentially puts into question the legitimacy of judicial review, where judicial review is appropriate. Yeah, that is, if people lose faith in the belief that the courts are in fact acting to interpret the Constitution within their appropriate constitutional role, there's a chance that you begin to erode the legitimacy of the courts themselves. And you don't need to use the language judicial supremacy, but just the appropriate role of the courts within a constitutional democracy. Yeah. So I think these are the two sort of concerns, and there will always be debates at the penumbra. There will always be debates at the borderline about whether or not a court is doing this or not, right? But this is, I think, a place where courts have to make decisions about restraint and about their appropriate role.
Emmanuelle, do you have any thoughts on this?
Yeah, the only thing I would add, I agree with everything that my fellow panelists said on the question, but the only thing I would add is that the courts have been, as of late, generous towards municipalities in the jurisprudence, and therefore, because this is the tool, one of the only tools that municipalities have, they should not give up on amending the Constitution through judicial review.
Boy, if I could come back to you, because let's remember the focus of the panel, which is how do we get cities the powers that they need to do the things that we need them to do for us? And you suggest, Hoy, that Section 43 could be used to give greater powers and protections to cities. I want to ask you to please explain to us what Section 43 is. What is that procedure? But I also want to note that your suggestion comes with a qualification, which is that Parliament must take its role seriously in Section 43. So the question to you, what's Section 43's procedure? And what is the significance of your qualification about Parliament's role in using Section 43?
Great, thanks so much, Richard. So, I mean, I think that Erin has already raised Section 43 and done a fabulous job of giving us an overview of how the different amending formulas fit together. So very specifically on Section 43, it's an amendment to the Constitution of Canada, so not the provincial constitutions, but the Constitution of Canada, and to any provision that applies to one or more, but not all the provinces. So on the plain language, this suggests that you can amend the Constitution of Canada in respect of one or more of the provinces. So if a province were to amend its constitution in respect of a municipality within its jurisdiction, right? This may be an avenue for amendment of the Canadian Constitution. Yeah. Now, as I say, this comes with sort of caveats and limits and qualifications. And one qualification that you're pointing to is the role of Parliament in this. Yeah, so that is it requires a amendment that affects one or all of the provinces. Also requires a proclamation issued by the Governor General under the Great Seal of Canada and authorization by the resolutions of both the Senate and the House of Commons. So the subject matter, the reach of Section 43 is one, some but not all of the provinces. The procedure required is both the provinces and Parliament have to come to an agreement to this. Yeah. So what does it mean for Parliament to take its role seriously? So I think Emmett has sort of taken us a little bit down that road. I think that one of the ways that Parliament can take its role seriously is by assuring that when it agrees to an amendment under this amending formula, that it is giving voice or giving effect to relevant constitutional values. Yeah. So Emmett talks about the unwritten constitutional principles. Yeah. But I guess the idea is that Parliament has to exercise independent judgment about whether or not it can authorize the amendments. Yeah, and that involves the kinds of interests that Emmett has pointed us to. Yeah. And so this is important. This is important because, as you and others on the panel have said, the amending formulas have different structures. So if Parliament does not take its role seriously under Section 43 and it's simply rubber stamping, then you collapse the Section 43 provision with Section 45, which allows for amendments by the provinces alone. So that's basically it. That's the structure of Section 43, both in terms of its scope and its procedure. And this is what it means for Parliament to take its role seriously.
Just one follow-up question for you, Hoy, if I could. Who can initiate an amendment under Section 43? You tell us that we need the approval of Parliament and we need the approval of one, some, but not all provinces that are implicated, but who can initiate, and does that matter? Does that open an avenue to actually amending the Constitution?
Yeah, so I'd say the provinces can initiate. Yeah, and so this is, I think, why this is a very promising avenue, is that the provinces can initiate an amendment process under Section 43. But you know, this raises a larger question, and I see that we had a question about electoral representation in the chat. The tricky question for Section 43, given the assumptions that we have that municipalities are disempowered by their provincial legislatures, if you require the provinces to initiate, under what alignment of political forces will such an amendment affecting municipalities be initiated? That's a kind of an essential question.
Mm-hmm. I want to come to you if I could, Emmett, because you agree with Hoy that Section 43 could be used to give greater powers and protections to cities. In fact, you suggest that Section 43 could be used to protect the power of cities over their elections, over their budgets, and also over their identity. I'd like you to explain, please, what you mean by these three categories, why they're so important in your view, but also, Emmett, why you stop short of going as far as others might wish to go. For instance, to make municipalities their own constitutionally recognized level of government.
Yeah, thank you. Yeah, I do think Section 43 offers the twin virtues of feasibility. That this is a procedure that we've been able to effect under the amending formula since 1982 on several fronts, but also provides municipalities with actual constitutional protection in that anything we might entrench as municipal powers in the Constitution could not be unilaterally withdrawn by the province. And that's to me the virtue of Section 43. I identified these three areas not so much as suggestions. I think there are three important areas with regard to local control over municipal elections. I think this is core to the democratic normative desire of giving municipalities more power. And many of the controversies we've seen lately in Canada as it regards provincial interference in local affairs has been in the realm of elections. I already talked about the Toronto City Council case. In another recent instance with the Ford government here in Ontario, they slipped into an omnibus piece of legislation a ban on municipalities adopting ranked ballots for elections. This is a decision that the City of London had already made and other municipalities were considering. And for unexplained reasons, the provincial government decided it was not going to allow cities to make this decision for themselves. I don't think that's warranted. I think local democracy and the attachment people have to their local communities is fundamentally important, and I agree with much of the scholarship on this point and the commentary on this point. And so I think elections are an obvious avenue from which we could give municipalities some of their own authority and shield them from unilateral interference by the province. With regards to budgets, I do think there'd be some room to provide some sort of consistent standard or protection for a base amount of funding given the responsibilities that municipalities have. And now right now municipalities draw on property tax and have other direct line budget funding given by the province in several areas. They even draw sometimes on federal funding for infrastructure projects and the like. But in the current constitutional arrangement, one provincial government could come in and give municipalities 1 point of the provincial sales tax revenue, and 4 years later, a new government could come in and just take it away. And so, given municipalities' responsibilities, it'd be nice to see some degree of protection and stability for municipalities in the budgetary context. Now, I don't specify what that necessarily would be, and I don't think it would be wise to embed something in the Constitution itself that would be too specific in this regard. But a threshold of funding levers for the municipalities would be wise, I think, for that reason. Finally, on identity, I think questions over whether municipalities are subject to amalgamation or whether other really core institutional features of a municipality has changed ought to be subject to local democracy and the constituents of those specific cities or municipalities rather than the provincial cabinet table. And so I thought that was just another obvious example of something that could be granted to municipalities as an area of constitutional authority. These are three examples. I don't present these as an exhaustive list of what should or shouldn't be included, but those are the three examples I present for those reasons. Now, why not go the full route and really push for municipalities as their own order of government? Well, I mean, if we were to take that in its fullest possible sense, that would mean including municipalities somehow in the constitutional amending formula. And if they are going to be a sovereign order of government empowered in the same way that the federal and provincial orders are, why wouldn't they be part of the amending formula? And the short answer to that is twofold. One is that would be enormously complicated. You would need to really figure out how to include municipalities in their own kind of exhaustive set of division of powers in the Constitution. And then we'd also need to use the unanimity amending formula to achieve it. That would be, I think, exceedingly difficult. I also think, we talk a lot about overlapping powers between the federal government and the provinces. Well, the overlapping powers between municipalities and provinces is even more, I think, complicated and more subject to perhaps distinct needs across the country. The relationship between the province and municipalities in a place like Prince Edward Island compared to a place like Ontario is quite different. And so I don't think it would be, to undercut it, I don't think it would be easy, let alone practical, to kind of try to establish municipalities as a full order of government in the sense we might understand it. And so I think my perhaps more modest approach of giving municipalities some constitutional authority and protection from unilateral provincial action is just the most feasible way to go.
Erin, I couldn't help but think of you and your own remarks about the complexity of amendment in Canada when Emmett gave as one of his reasons why not to go as far as some would. Why not to go as far as some would? Because it would just make it even harder to amend the Constitution of Canada. Do you see it the same way?
Right. Yeah. So whenever we're talking about amending the amending formula, I think we're so far away from that in terms of our constitutional politics that it's not that we shouldn't be talking about it, but there are many, many other things that we can talk about first and feasibly get done. And I think, as has already been said, we already have a tremendously difficult amending formula, even when we're doing well in terms of our constitutional politics, when people are seeing eye to eye on things. So certainly, if we're asking the question, how do we want to see cities transform in terms of constitutional status in the near future, I think we really do have to focus on sections 43 and 45, and particularly with section 43, I think there is a lot of room there. And as Foy was saying, and it's a point that he makes in his paper, and I hadn't thought about it until it was pointed out, that the role the federal government should play when we're talking about this bilateral amendment formula, that it shouldn't just be a rubber stamp. I do think I had taken that for granted, because if it is a provincial initiative, you would imagine that the federal government should be willing to go along with it. But on the other hand, there is a reason why it's a bilateral amendment formula, that both parties have a role to play, and that there should be a conversation that happens there. And I think that would be interesting to see. And I would hope that the federal government would be more willing to engage in those conversations when they're more narrowly focused in a way that it hasn't been in the past.
Boy, let me get back into the conversation. You've just been invoked because of the point you make in your paper, and that you made a moment ago about Parliament's role, the seriousness with which we should take Parliament's role. Let me ask you to combine a response to that with an answer to the question, how far should we go? Should we take the moderate approach, let's say, maybe plausible, maybe a realistic approach, Emmett might want us to describe it as, or should we go all the way to constitutionalize this third level of government? What are your views on that?
So just to make sure I got the questions right. So there's a question about how far we should go, and then there's a question about you're asking me to clarify the role of Parliament. Was that
no? I just wanted you to comment on Erin's observations about your own rendering of Parliament's role.
Right. So this is great. This is getting kind of meta. It's like I'm going to like comment on Erin's comments on my comments. Okay, great. Yeah. So look, I think that it's right that what sort of gives the Section 43 amending formula, its sort of unique function within the constellation of amending formulas is that it actually does assign a role for Parliament. And just to take Erin's point a little bit, maybe one step farther, I think it's what it means, and I think Emmett sort of hinted at this. It's what it means to have effective entrenchment in this context. Yeah, if Parliament weren't playing an effective role, then you effectively have provinces able to simply unilaterally override their Section 43 amendments, right? And that doesn't seem to make sense given the structure of the different amending formulas. So that's just on me commenting on Erin commenting on me. Let me turn now to the question of the extent of the amendment, of how far we want to go for the cities. Look, I think it's there are questions of political reality, right? So as both Emmett and Erin have said, there is this question about, do we really want to open this up? And do we really want to work around the existing amending formulas, which if we're creating an independent order of government along the lines of a province would require unanimity? So there are political constraints. Now, if you're asking me the question as a normative question, there is, I think, a plausible case to be made that at least the largest cities in Canada have features that make them resemble very much provinces as orders of government. Yeah. So if we're speaking purely normatively, at least for some of the cities, you have entities that are kind of indistinguishable from what we would think are the sort of defining qualities of a province. Yeah? That is, they are communities of interest. They have sufficient political weight. People shape their lives within these jurisdictions, right? They have enormous economic impact. Yeah. So if we were speaking purely normatively, I think there's a case to be made. The question is, this isn't a purely normative exercise. Yeah. This is an exercise that's constrained by the existence of our constitutional formulas and political realities on the ground.
So we've been discussing so far how to give cities the powers that they need to do the things that we need them to do. We've talked about Section 43. We've set aside some of the procedures in Part 5 of the Constitution Act. I want to get to some other ideas, including creating provincial constitutions, rather codifying them, formalizing them. But first, I want to come to the S word, and I want to come to Emmanuelle Richez, because in your paper, Emmanuelle, you evaluate a number of options for constitutional reform. And one is the quite provocative one that I want to ask you about, the S word. You say that cities might consider secession from Canada. Question for you. Is this permissible under the Constitution of Canada? And if it is, would it be a good idea for a city to consider?
Well, the short answer to your question is that it's possibly constitutional, but it's highly unlikely. So if we look at the Canadian Constitution, there is no mention of how a province can secede from Canada, let alone a municipality. However, in the Quebec secession reference, the Supreme Court identified the process by which a Canadian province can secede from Canada under the Constitution. So in a nutshell, the Supreme Court said that if there's a clear provincial majority in favor of secession, on a clear question, then other Canadian governments have a duty to negotiate with that province, whether or not this leads to secession. And what the Supreme Court said also is that it would require a constitutional amendment. More precisely, the amendment would require, on the one hand, a clear provincial majority in favor of secession, but also a clear majority of Canada as a whole, whatever that may be. So the Supreme Court did not specify what is entailed by such a majority. It left it to political actors to determine what it means. Now, since the reference discussed this provincial secession, a lot of scholars question whether this would apply to cities. In my view, it would, because if we can't ignore the democratic expression in favor of secession for a province, we can't ignore the expression of a democratic will coming from a city. Just to put things in perspective, the metropolitan area of Toronto has a population of 5.9 million people, whereas Prince Edward Island only has 142,000 people. Now, is it a good idea? Well, it would be very difficult to pass such an amendment, especially with the double majority requirement. But the reason why secession is highly unlikely is because there's simply no appetite from Canadian municipalities for secession. And there would be also no sympathy from the international community for a municipal secession, because in general, people are skeptical of groups trying to attack the territorial integrity of long-standing government unless a population is under colonial rule. And this is not the case of Canadian municipalities. If we look at the province of Quebec, whose sovereignty project is based on cultural preservation, it never got the sympathy from other federative partners. So there is in Canada constitutional patriotism where people favor national unity, and so secession of municipalities is not really an option. And if there was a municipality that wanted to secede, it's unlikely that the province and the federal government would agree to it, because it would mean a loss of revenue for them.
Okay, so we've talked about a number of options now. Section 43, secession is one. Let's talk about provincial constitutions now, if I could, and I'll go to Erin, because another innovative way for cities to acquire greater powers is for a province to entrench a constitution of its own, to codify a constitution of its own, and to use that as a vehicle to in turn confer powers upon cities. Sounds promising. You explain in your written contribution for this program, Erin, that provinces, of course, already have constitutions of their own, and moreover, that those constitutions already recognize cities as part of the provincial constitutional architecture. So as we dive into this discussion, Erin, about provincial constitutions, could you just tell us what is a provincial constitution and how are cities already part of them?
Right. Yes. So this was my attempt at being provocative in my paper. Are cities already part of constitutions? And it might not be a convincing argument, but the idea is that it opens up the discussion in a different way. So let me start by saying that many people might be surprised to know that provinces have constitutions because they have a fairly low public political profile. So it might be helpful to ask, what is a constitution, which is also a big question, but a constitution can be, but it does not need to be contained in a single document called the Constitution. So in Canada, we probably think of the Constitution Act of 1867 and the Constitution Act of 1982 as our constitution or our constitutional documents. But this is part of the Canadian Constitution. It is not all of the Canadian Constitution. And when we're talking about provincial constitutions, there's very little that is singular about them. And as you've noted, they're not, or they're largely not entrenched. So for provincial constitutions, they come from multiple sources, including portions of the Constitution of Canada, ordinary provincial legislation, common law, and the unwritten constitutional conventions that are typical of Westminster style governing, which is the system of governance Canada has. So for our current discussion, an important example of one of these conventions is parliamentary sovereignty, for example. And despite this ambiguity, there is some consensus that certain statutes are part of a province's constitution, including the rules of a province's electoral system, the legislative processes, executive governments, judicial acts, and human rights codes. But we should also say that this list shouldn't be viewed as exhaustive. And it's simply the case that we don't have a definitive list of what statutes are contained in provincial constitutions. And then we have the ambiguity around or created by the amendment procedure under Section 45, which can amend provincial constitutions, which requires only statutory enactments by the provincial legislatures rather than parliamentary resolutions passed by provincial assemblies. So this means that amendments to a province's constitution proceed by way of ordinary statute. And as a consequence of this, there is no requirement that an amendment to a provincial constitution contain any sort of distinctive cue that can identify it as a constitutional amendment. So while there's nothing that would stop a provincial assembly from identifying the use of Section 45 in a statute, and this has happened at least twice since 1982, provinces as a rule do not do this, which means we do not have a record of amendments to provincial constitutions under Section 45. So it's totally reasonable to believe that amendments to provincial constitutions happen on a regular basis, but we don't have a good way of identifying these amendments. The position that I take in the paper and want to talk about here is that given that we can't identify all components of provincial constitutions, and that the amendment procedure under Section 45 only acts to further obscure provincial constitutions, there is arguably uncertainty around the status of Canadian cities and provincial constitutions, simply because we don't know or we can't be confident about what a provincial constitution contains. So here I should stop and say that Canadian municipalities are not recognized by the federal government or any provincial government as having constitutional status. And current jurisprudence affirms this view. So this is a proposition. So the proposition that Canadian cities may reside in provincial constitutions is by no means an easy argument to make. And it may very well not be the correct argument, but again, it's a means of having a conversation. And that being said, there are factors supporting a view that the status of cities and municipalities are part of provincial constitutions. So a number of scholars have argued municipalities and municipal systems are fundamentally constitutional in nature. And so just to start, cities further the principles of democracy and federalism, which underpin Canada's constitutional architecture, as has been recognized by the Supreme Court in the secession reference and later affirmed in the Senate in the Supreme Court references. And my larger point in asking the question, are Canadian cities already part of a provincial constitution, is not necessarily to convince you that they are, but I would be happy if you were convinced, I think, but rather to encourage us to think carefully about provincial constitutions as political constitutions. So political constitutions, and what that might mean for further efforts to constitutionalize cities or more generally entrench provincial constitutions. So for background, the frameworks of political and legal constitutionalism are developed in British constitutional theory. A political constitution can be distinguished from a legal constitution most easily in terms of where political power is held to account. For a legal constitution, it is primarily the courts through judicial review, whereas for a political constitution, it is more so the day-to-day political activity of Parliament. So it's Parliament itself that is enforcing the Constitution. So in very simple terms, legal constitutionalism embraces constitutional supremacy, whereas political constitutionalism embraces parliamentary supremacy at the two extremes. How does this relate to Canada? The Constitution of Canada can now be best understood as fitting a legal constitutional framework. Whereas provincial constitutions, at least when we're talking about constitutional conventions and statutes where the constitutional amending procedure under Section 45 applies, still follow a political constitutional framework. And this matters for constitutional politics. There are clear political benefits for provincial governments of all political stripes, regardless of their political ideologies, to maintain this political constitutional framework as it serves to entrench political power in the political executive, and it makes their job of governing easier. A political constitution works in the favor of the governments that control the legislatures, essentially. So when we are talking about entrenching a provincial constitution or entrenching cities into a provincial constitution, we're also talking about a transition from a political constitutional framework to a legal constitutional framework, which brings with it not necessarily constitutional barriers, because Section 45 is pretty easy to use, very easy to use, but rather the barriers are political. And I think that when we're discussing changes to provincial constitutions, it's helpful to consider them in these terms of political versus legal constitutionalism.
I think it's very helpful, Erin. Thanks for that. And I have just a couple more questions, and then I'd like to go to the floor because we're getting a lot of questions and comments. And so please keep them coming. But I want to go, Erin, if I could, to that transition from a political constitution to a legal constitution. And I want to invite Hoy and Emmett to have a kind of a colloquy, because it appears there is a point of tension in how they view a certain point that you'll soon hear about. So Hoy, provincial constitutions are quite complex, just like the Canadian Constitution. Let's assume that we want to do this transition from a political constitution to a legal constitution. So assume that a province wants to codify and formalize its own constitution. And in the process of doing that, Hoy, the province wants to give greater powers to cities. This is the devolution model that Emmanuelle started off with. Would there be any constitutional limitations to creating this kind of a codified, formalized, entrenched provincial constitution?
So this is such a good question. So the provincial constitutions, as Erin has helpfully pointed out, are the constitutions that deal with the basic structures of governance of the provinces. Yeah. So if you want sort of a shorthand way of thinking about them, they bear on the political organs of the provinces. Yeah. Okay. So what this means, however, is that any amendment to the provincial constitutions cannot infringe the Canadian Constitution. They cannot infringe the larger constitution within which the provincial constitutions are contained. Okay, so one limit with respect to cities being entrenched in a provincial constitution is the express language of a Supreme Court case, 1987, the opposite case, Ontario Public Service Employees Union case against Ontario, which expressly excludes from amendment through the provincial constitutions of any provision that falls within the division of powers, sections 91 and 92. As we've all heard, the municipalities fall within section 92. So on the express language of that decision, right, entrenchment of the kind that we're talking about, changing a constitution to allow for recognition within the provincial constitution is expressly excluded by a Supreme Court majority that has not been touched since. So that's one limit. Yeah. It's a limit that's imposed by the larger Canadian Constitution within which provincial constitutions operate. Okay. So the larger question, and this is, I think, the question that Erin very helpfully raises, and I think Emmanuelle sort of gestures towards with her arguments about secession, is this distinction that Erin draws between political and legal constitutions. So there are various ways in which you can think of entrenchment, right? So I've already suggested that one way is off the table is because of the sort of an express judgment of the Supreme Court of Canada. But you can think of something like a manner and form requirement. That is a requirement that legislatures say something or do something when they decide that they're going to amend their legislation. And so things like these things happen in things like Human Rights Acts, right? So that if you're going to legislate in a way that's inconsistent with the Human Rights Act, you have to do it explicitly. You have to say we're expressly derogating. Yeah. So the question is, and what kind of a entrenchment is that? And I think within the terms that Erin has set for us, it's effectively a kind of political constitution. Yeah. That is, what is the cost of not doing this? What is the cost of signaling that you're making this kind of fundamental change? The assumption is that it attracts political attention. Yeah. Okay, so I think that those are the sort of boundaries of the discussion about what entrenchment means in this context. And I look forward to hearing what Emmett has to say on this.
Emmett, let me bring you into this conversation specifically about the manner and form requirements. So can a legislative assembly impose manner and form requirements that make it harder for a future legislative assembly to undo a law, in this case, part of the Constitution?
Yeah, I mean, so I don't know that I'm far off from anything Hoy has said so far. I struggled with this proposal in my own paper. Kristen Good has an excellent paper, and part of it discusses manner and form requirements. I think she's a little more optimistic than I am at the end of the day, but it's a fantastic discussion if anyone wants to do a little extra reading. So what about the legitimacy of manner and form requirements? Part of it depends on how we understand what would count as a manner and form alteration to a provincial constitution. So Peter Hogg has written in the affirmative on this question. He points to the elimination of upper houses from provincial assemblies as an example of a manner and form requirement. And can provinces get rid of their upper houses in their legislatures? Yes. I think the answer is clear because many of them did. The Quebec Charter of Human Rights is an example that Hogg also cites of a manner and form requirement, in that we have conferred upon that ordinary statute a quasi-constitutional status that subjects other statutes to it. And the Quebec courts and the Supreme Court can enforce the Quebec Charter in a way that treats it as what, at least as Hogg saw, as a manner and form requirement. That seems legitimate and valid. I mean, I think for our purposes, you know, in looking at Section 45 as a possible avenue here, is really, can a provincial legislature implement a manner and form requirement to a change such as requiring a supermajority for subsequent repeal or changes to municipal powers that are granted to it? And that's where it gets tricky for me, because you do run into this principle of a legislature not being able to bind future legislatures. If I recall correctly, you know, Kristen Good's response to this was, well, this is the type of thing that should be limited to changes specifically of a constitutional nature. And that brings us back to Erin's comments and Hoy's comments about the difficulties. First, the difficulties of identifying always what counts as part of the provincial constitution, but secondly, some of the limitations that Hoy is speaking to. My other more political concern is, how do we limit the use of manner and form requirements to these purposes and to changes of a constitutional nature? What is to stop a perniciously cynical provincial government from saying, well, we have this legislative agenda, and if future parliaments or future legislatures want to repeal these, it requires the unanimity of the provincial legislature. On what principle can we allow kind of the requirements for supermajorities in some contexts and perhaps not others, or the requirement for reasonable supermajorities but not unreasonable ones, that like unanimity, that effectively run headlong into all sorts of other, I think, principled objections? I don't know the answers to that. And so given I can't necessarily identify the limits on the use of manner and form requirements, I get very uncomfortable with them beyond perhaps the type of manner and form requirements that Peter Hogg cites as having occurred in the past.
I want to come to the audience's questions. I have one more question I'm going to ask to Emmanuelle, Richez in just a second, but first a detour. Hoy, Kong, and I are working on a book about provincial constitutions in Canada. And in that book, Hoy, we have a contribution from Ted Morton, who makes an argument about symmetrical entrenchment, a way to get around this manner and form problem. He suggests that legislative assembly could entrench a constitution in the following way: bring it into force by, let's say, a 2/3 vote, and say that it cannot be amended by a further 2/3 vote. This is the idea of symmetrical entrenchment. What do we think of that? Hoy. What do you think of that, Hoy? And Erin, I'd love to have your reflections on that as well. And then we'll come to our last question to Emmanuelle Richez and then to the floor.
Yeah, great. So I think it runs into the problem of parliamentary supremacy within the Canadian constitutional system, right? That is, the fact that you've decided to bind yourself to a 2/3 procedure and then require that in the future doesn't remove the problem of parliamentary supremacy, right? And so I think that's the basic challenge. And the idea that this is sort of congruent with the standard what has been recognized under Canadian constitutional law as manner and form, I think it's qualitatively different, right? For the reasons that I said earlier, the manner and form requirements that we typically have within Canadian legislation, right, are not that. They do not constrain government in that way. And even the clearest example of a manner of form requirement with respect to sort of, I guess, what you would call a kind of quasi-constitutional statute in the Mercure case, which is about the Saskatchewan Act. That's so even that is sort of at the limit, right? That is, in order to amend that act, you have to conform with the bilingualism requirements that pre-existed it. Even at that limit, right? Even with that recognition within the Canadian constitutional law, that is not a supermajority requirement. And against a supermajority requirement, you have just decades of jurisprudence affirming this as a constitutional principle. So I think the more likely possibility if this were to arise would be that it would be the principle of parliamentary supremacy would be recognized as a constitutional principle that would limit the capacity of legislatures to do this.
Fascinating. Erin Crandall?
Yes, so I think it's pretty clear that this is an issue that is ripe for challenge. If we ever saw some sort of manner and form statute put into place and a future government was interested in disregarding it, certainly we could anticipate that a court case would come up. And I think ultimately, and it goes back to Emmett's point, it's really going to speak to the type of legislation that it's attached to. So if there's a manner and form included in a piece of legislation that expands voting rights, and then a government is seen to try to take away those voting rights by disregarding the manner and form threshold, that's going to come with hefty political costs because the optics of that are terrible. And so I would think a government would be less likely to take that measure and to assert parliamentary sovereignty depending on the content of the legislation itself. And so this becomes less a question of the constitutionality of manner and form provisions, but more of the political costs of disregarding them. It's politics and non-constitutional law. But I would suspect if it came to play out, that the content of the legislation would matter a lot. And if it was intended to expand rights, for example, if we were talking about election law or to expand the franchise, it would be very difficult to disregard that higher threshold. Whereas if it was something that was less popular, that you could probably get around it. And then we would see how it plays out in the courts.
This has been just such a fascinating conversation. I think it's a whole new research agenda that builds on the work of some colleagues who are in the attendee room right now, including Kristen Good, who's been referred to in our discussion so far. Let me now come to the last question I want to put to the group and then come to the floor. And I intend this question, if I could, to be kind of summative of our discussion in some way. And I come to you, Emmanuelle, because you have created a helpful table that summarizes at least some of the options that are available to cities if they wish to increase their powers by constitutional amendment. And so I'd like for you, I see you've done it already, if you could just show us that table and then walk us through some of those options, and then we'll go to the floor for our discussion. Thank you.
Oh, can you see it?
I can see it, yes.
Perfect. Okay, so in this summary table, I list the 4 ways to amend the Constitution from the most unlikely to the most likely. So first, you have the secession amendment. Second, the general amending formula. Third, the provincial amending formula. And finally, the micro-constitutional amendment, which is judicial interpretations of the Constitution. You will see that I did not include the bilateral amendment in my table. However, it would fall between the general amendment and the provincial amendment. So my qualitative ranking of the different amendment types here is based on the consideration first of the codified rule itself, i.e. what is needed for an amendment to pass, but also on the norms of constitutional change, i.e. whether a referendum is needed to lend legitimacy to the amendment, the intensity of political polarization, i.e. whether political actors agree or disagree on the content of the amendment, and the degree of constitutional veneration, i.e. whether the amendment puts into question the way Canadians see their country. So as we can see, the rigidity of the codified rule has an undeniable impact on the likelihood of a constitutional amendment. So the more political actors are involved and the higher the degree of consent required, the lower the chances of municipalities gaining powers. However, what's important to notice here is that the rigidity of the codified rule is not the only determinant. So the secession amendment and the general amendment rules are both very rigid, the general amendment being the most rigid. However, municipal secession is less likely than the transfer of federal powers to the cities via the general amending formula, primarily because of the higher degree of constitutional veneration involved. So there is simply no appetite for breaking the country. So I'll leave the discussion to the floor now.
Great, thank you. We'll just ask you to stop sharing your screen so that we can see you and your fellow panelists again. And let me just put a couple of questions on the table for the panel. I want to put two on the table. One from Professor Mariana Valverde and one from Professor Kristen Good. And I invite the panelists to comment on either or both. Professor Valverde asks, so far campaigns from civil society to strengthen local democracy have been quite separate, often single issue. I'm quoting, the federal NDP, for example, has pushed for proportional representation, but the federal Liberals and the Conservatives will never agree to that. Again, I'm quoting. On their part, John Sewell and others promote city charters. Others have argued that permanent residents ought to be able to vote in local elections, something that would be very significant in some parts of Canada. The question, still quoting, why don't we have a broad movement for local democracy in this country that promotes all of these ideas as well as supporting constitutional change? One question on the table for you. Second question from Professor Kristen Good. I'm wondering whether the participants could reflect on the written constitution and the role that was meant for provinces in the system given many of its quasi-federal features, and what this means for how we should see section 92.8. Let me put a third question on the table in case your interest is not piqued by these first two. Mine certainly is. From Professor Thomas McMorrow. Are there different constitutional cultures within Canada? Any that demonstrates greater respect for municipalities, seeing that their exercise of responsibility requires corresponding economic power? So three questions, choose your own adventure. I want to try to get as many questions on the table. Please, we'll start with, top on my list is Emmett, then I have Emmanuelle, then Erin, then Hoy.
Well, I mean, the first question struck me as really interesting, and I try to turn the cynical part of my brain off sometimes, but it's been dominant lately. Local politics, at least by way of elections, is tend to show the lowest levels of engagement among voters in Canada. And we already, live in a culture with a fairly high degree of apathy and alienation from politics. Now, that doesn't mean people aren't engaged in politics at a local level. They just often aren't engaged in electoral politics. And it seems natural flowing from that, that the object of a lot of lobbying activity or social movement or interest group organizational activity devoted to political change is often devoted to substantive policy areas rather than questions of political process. I think it's a wonderful question, and you do wonder why you don't see perhaps a much stronger movement for having permanent residence vote at the local level, and why that wouldn't catch on, particularly with partisan vested interests who might like to capture permanent resident votes at, say, the provincial level, for that matter. Again, nothing in the to my mind, nothing in the Constitution actually necessarily prevents the expansion of the franchise in this way. It just seems to me that much of our within this culture of apathy and alienation towards organized politics, that seems tougher to break through than maybe people devoted to more issue-oriented concerns.
Yes, we have the order already. Emmett, Emmanuelle,
Okay.
Erin,
Yes,
and Hoy.
so I'd like to address the question regarding culture. It's a good question, and I think there is definitely different constitutional cultures in Canada. For example, in Quebec, Quebec has initiated several macro-constitutional negotiations throughout the last 70 years. Even lately, the Liberal government of Philippe Couillard tried to ignite again a constitutional debate on the place of Quebec within the Canadian Federation, but the other federative partners didn't really get engaged into this debate. But what's interesting is the culture in BC. So in BC, much more attention is given to the will of the people. So for example, if there is a future constitutional amendment, the BC government is required to get the approval by referendum of the British Columbians before agreeing to an amendment. And also in BC, in 2008 or 2003, I believe, there was the community charter that was put in place, which recognizes that municipalities have jurisdiction over certain matters, that if there is a dispute between municipalities and the government, some mechanisms are put in place.
Great. Just building off of Emma's point about there being different constitutional political cultures, I absolutely agree with that. And I think we can especially see that in Quebec, where there's been multiple efforts to entrench provincial constitutions. And also we're thinking about this type of mega constitutional politics that hasn't happened in recent decades, but when we're talking about Meech Lake and Charlottetown, that these are amendment formulas that involve both the provinces and the federal government. And I think in those cases, there is a shared political constitutional culture because all provinces were impacted by that in terms of political fallout. So the type of political trepidation that we see with the federal government, we could also, I think it's reasonable to expect it in all of the provinces as well, because when we're doing larger scale constitutional amendment in Canada, all the provinces and the federal government, parliament is involved. On the first question about kind of more grassroots initiatives, I'll just give one example that I was a part of a couple of weeks ago. There's a group called Lost Votes New Brunswick, which is pushing for the rights of permanent residents to vote in municipal elections. And interestingly, in New Brunswick, permanent residents could vote in municipal elections up until 1997. And then it was removed. It was which was something, well, in any case, now they're pushing to have it move forward. And it's really heartening because, of course, it's local people working to have this done. And it's a really compelling argument. And it does seem to have traction amongst the cities that have endorsed their position that permanent residents should vote in New Brunswick. And so because it's New Brunswick, I don't think there would be as much attention to it in other parts of the country. Even within New Brunswick, attention would be limited. But I do think that there are pockets certainly pushing for that, and we can see it in New Brunswick, and hopefully if that happens, that permanent residents can again vote in New Brunswick, that would have a kind of domino effect, and we could see it in other parts of the country.
Great, such a great set of questions from the floor. And hi, Marianne. So nice to see you virtually. So I'll take Marianne, Professor Valverde's question. And I think there's actually an answer to how to increase a movement for broad city power. And it starts by overturning a Supreme Court decision from 1991, which is the reference-free provincial electoral boundaries case, the Carter case. Yeah, because that case entrenches the possibility of significant disparities in voting power. Yeah, and those typically happen between urban and rural ridings, right? So I think if we could reduce the amount of disparities, then you would begin to give more power to the cities within provincial legislatures. And this also goes to Professor Good's question. Yeah. And so you begin to address the sort of source of the problem, which is that provincial governments can disregard their cities because they don't have to pay a political cost for them for doing so. Yeah. So the first move, I think, is to increase the electoral power of city voters. And that begins, I think, by challenging this case. So that's on the sort of, how does that affect ordinary law, ordinary politics? On the constitutional level, which I understood to be the second part of Marianne's question, if one of the barriers that we see to constitutional amendments is the unlikelihood that it is unlikely that the provinces and will come together and the federal government will come together, increasing the political power of city dwellers may push for constitutional change with respect to their interests. Yeah, that is, if city dwellers have their interests represented within the government, that increases the possibility of overcoming even onerous amending formulas restrictions. Yeah, so I think the general response to the underlying problem of why there is not a movement for broad city power is because city residents are disempowered within this existing constitutional structures. The only way to change that is to empower city residents.
Thank you to all for this first round. I regret we only have 7 minutes left in this discussion. So let me just put one question on the table. Let's see how we do on that. And we'll reverse the order. So we'll hear from Hoy first, then Erin, then Emmanuelle, and then Emmett. Question from Professor Howard Cass. Does the fact that mayors and councillors in major cities run without formal affiliation with provincial and national parties, does that hinder reform efforts? One might also ask whether it helps potential reform efforts. Please.
Hard question. I think the short answer is I'm not sure, because I'm not sure that aligning party affiliation at the municipal level with the federal or provincial level means that there's an alignment of political interests, right? So there are many examples across Canadian history, and especially with the Quebec Liberal Party, of parties having parties with the same names having different alignments on specific political issues. And so I'm not entirely sure that an alignment of party affiliation yields necessarily an alignment of political interest.
Boy, by the way, there was a question that just popped up directly for you, which built on a point you made in your earlier intervention. What would be the legal avenue to overturn Carter? And this is from Professor Zach Taylor.
Sure. I think that and this is building on the work of Mike Powell and Sujit Chowdhury. I think one of the side effects of this unequal representation within provincial legislatures, let's just say with the provinces for now, is that is because of the demographics of cities, this represents an underrepresentation of people who are protected, minority groups who are protected under the Canadian Charter via Section 15. Yeah. So I think the sort of easiest route is to sort of say, look, the existing constitutional rules, the existing distribution of voting power, disadvantages through a process of adverse effects discrimination, not direct discrimination. It does not single out these groups, but indirectly affects their interests in demonstrable ways. Yeah. And given the recent, I think, expansion of the doctrine around, and this is not the place to have this conversation, but around adverse effects discrimination or clarification around that doctrine in the Fraser case, I think this is actually a pretty promising avenue for challenging the existing distribution of voting power.
Great. Well, let's go back to the queue. Erin, Emmanuelle, and then Emmett. I'm going to add a question in case the first one didn't pique your interest. This is a question from Thomas McMorrow again. We've come to him twice now. Do you think cities will necessarily be governed better if their powers are constitutionalized? I'm quoting, can protection from a premier Ford not also mean too much power for a mayor Ford? So pick your poison, choose your own adventure. Erin, Emmanuelle, and then Emmett.
Great, thank you. Like Hoy, I'm not sure that political affiliation in terms of political parties would make a difference in terms of the likelihood of there being movement on constitutional change or increased autonomy for cities. Even though most cities don't have political parties, I think for provincial and municipal players, it's easy for them to tell whether or not their politics align. So it will probably come out to play in any case, and some will agree and some will disagree. And that's inevitable in politics. And then sorry, Richard, could you repeat the second question?
Second question is from Thomas McMorrow, and I think I've lost the actual text.
Oh, will cities necessarily govern better?
That's right.
If they have more power, right? No, I mean, no. But they could, in terms of not having to experience interference from a provincial government, although that interference might not necessarily be good or bad. I think I was listening in on a panel yesterday, and one of the panelists very wisely said that, you know, if you're talking about constitutional amendment or greater autonomy for cities, there's no normative attachment to that. The assumption is it will be better, but that's not necessarily the case. We can see that cities have a history of discrimination and racism, just like our provinces in our country. And so we shouldn't assume just because it's local, it will necessarily be better. I think that's why we need to be quite focused in terms of what we're talking about when we're talking about giving cities more power. What powers are those, and what are their ends? And yeah, so we do have to be thoughtful about it, but the working assumption cannot be because it is local, it must therefore be better. That certainly can't be the case.
Great. So let me invite Emmanuelle and Emmett each to take no more than 60 seconds. Pick one of the questions or answer both, and then we'll close the panel as we're nearing 12:30 or 1:30, depending on where you're calling from.
Yes, to go back to the question about municipal political parties, I'm not sure what the answer is, but what I can say is that there are definitely informal ties between municipal councillors and provincial and federal parties, because they have the same volunteers working on the campaigns.
I think with both questions, a lot depends on which municipality we're talking about, right? Some municipality, the city council, the municipal council works very well in a consensus-based model. Others are riven by ideological or unstated partisan differences as it is. And so attaching a partisan label may or may not make any different, may make things worse, may make things better. In terms of the power and authority of any given council, if powers were entrenched, again, like, I mean, what would we say if that question was about the federal government and the provinces? And I just don't know how to answer it. What entrenching powers might do in some contexts is make municipal councils more responsive to local constituents, because they're not being overridden in certain areas by by the provincial cabinet.
Well, this has been really just magnificent. I didn't introduce the panel in this way, but this was my dream panel when we set out to organize this panel on cities and constitutional change. This was it, and we're so pleased and glad that we're able to bring you all together today. I want to thank each of the panelists. I want to thank the co-conveners, Nathalie Desrosiers, Alexander Flynn, Alan Kaspersky. I want to thank our entire team, which includes Darren Chow, Selena Zhang, Jamie Bejian, and Diego Rada, who's our rapporteur for this panel, who's taking notes as you all were speaking, because we're going to post a little summary online. And of course, our supporters and sponsors, the Canadian Urban Institute, the Maitre Foundation, Massey College, and the Social Sciences and Humanities Research Council of Canada. Thanks to all for being here. The program continues in about 30 minutes, if I'm not mistaken, 29 minutes for our next session. But thanks to the panelists, we look forward to seeing you in person at some point sooner than later. Thanks to all. Be safe. Bye-bye.